Hello, I'm Michael Davis. I'm a Spanish inheritance lawyer. I've been handling probate, wills, inheritance tax, inheritance-related litigation for expats all over Spain since 1996. Today, we're going to talk about going to court to distribute an inheritance. In my view, the main objective of a decent lawyer should be to find the best solution possible for the clients. Well, in the case of an inheritance, I can tell you without any doubt that the best solution is to reach an agreement and not go to court if it is at all possible. To achieve this, the best thing would be if, as a group, you all went to one lawyer, if you could agree on one lawyer, to help you to explain to everyone what they're really entitled to, and therefore try and reach an amicable agreement. Many disagreements are normally based on one of the beneficiaries receiving wrong information, which is not strange because inheritance legislation is very complex, and they may have expectations that are too high. On other occasions, they just sort of decide to be passive and not accept inheritance, and it causes problems. So sometimes there'll be no solution but to go to court. But it is, as I say, a long and expensive procedure, and wherever possible, it should be avoided. What we always say is that if you all go as a group to a lawyer and he recommends a distribution in, a determined way, and if there's one of the beneficiaries that doesn't trust that lawyer or still doesn't agree, then the best thing is that as soon as possible that they find another lawyer to represent them. Normally, it's easier for us lawyers to agree on things between us than for the beneficiaries to do so, because we're aware of how complex it will get through the court, and we also know basically what a fair expectation is regarding the outcome. As I said before, we have to try and avoid the court procedure if possible, and by reaching an amicable agreement. Well, okay, let's say not amicable, but to reach an agreement. Okay, the reason why we're so heavily against the court procedure is that it's very long and very expensive. Long because there's actually 3 separate procedures, and then there are various sub-procedures as well. And expensive because apart from the lawyers that you'll have to pay, that's us, you also have to pay valuers to value all the assets, and then partitioning accountants, okay? And all this can become expensive. So what are these 3 separate procedures? Okay, well, one is the actual formation of the inventory and the distribution. In other words, a decision regarding who receives what. But also, we have other 2 procedures. One of the procedures is called the intervention. In other words, it may be necessary to get the courts to intervene the inheritance to avoid it losing its value for whatever reason. Again, they may choose people to take care of this. And apart from the intervention, there's another procedure called the administration. In other words, the courts will have to name someone to administer the estate. These 2 procedures that we've just mentioned don't always take place, and they don't necessarily have to take place in like this order 1, 2, 3. They can all be happening at the same time. But the procedures 2 and 3 normally are only used in large inheritances. For example, there's a company that's got to, they have to keep it running. There are more complex issues. So normally the one that we're dealing with is the first procedure, which is basically the procedure to form the inventory and to distribute the estate between the beneficiaries. Okay. Who can actually initiate the court procedure to distribute an inheritance? Okay, well, the person that can initiate the procedure needs to be a person that can prove that they are a beneficiary. And how do they do that? Well, the simplest way is if the will names you a beneficiary. For example, if for that you need to have a death certificate, a certificate from the Central Register of Wills, confirm which is the last will, and that last will that's mentioned in the certificate. The other thing that document you can use to initiate the procedure to distribute an inheritance is what's called the Declaración de Herederos document. Now, when in Spain, when there's no will, you follow an intestate procedure, which then ends up in a document called the Declaración de Herederos. It basically just names who the beneficiaries are, but doesn't establish any kind of distribution. And the third way that you can establish, you'll be allowed to initiate this procedure to divide up inheritance is if you have got a sentence from a court stating that you are a beneficiary of an inheritance. And what court do we have to go to initiate the procedure? Well, it's the Juzgado de Primera Instancia, which means the first instant court. And you have to go to the one of the last domicile in Spain of the deceased. Very often in our practice, where we deal with a lot of foreign people and the people of deceased abroad. If that's the case, we have to go. We can choose between the Juzgado de Primera Instancia of the last domicile that person had in Spain before they moved away, or to the court of the Primera Instancia, where the majority of the assets are situated. So the first step of the procedure is going to be that the secretary of the courts is going to call us in for a hearing, and basically he or she expects us to present, each of us to present an inventory of assets. If we can all agree on what the assets consist of, then that will be the final inventory of assets. If we can't agree, which is very normal, then the court secretary will then basically set another date for us to have a trial hearing just to deal with determining what the inventory is going to consist of. So once we've got the final inventory that could have been agreed by that hearing with the Secretary of the Courts, in which we've all agreed on the inventory by agreement, if that doesn't happen, we're going to have the trial hearing, and it will be the judge that will decide on what the final inventory is. Once we've got that final inventory, the Secretary of the Courts will call us in again for what's called the board of beneficiaries. Okay, and together we're going to try and agree on choosing both valuers and partition accountants. Okay, if we can't agree on that, then the courts will decide for us. They just do a little lottery between approved valuers and account partitioners of the courts, and they will make that decision for us. By law in Spain, they cannot use more than one valuer for each type of asset. So, for example, you can't have two different valuers to value real estate. So there'll only be one valuer for real estate, for example, one expert. Once the valuation of all the assets, the appraisal has taken place, the partition accountant will divide up the inheritance, and he will do it in accordance with either the law, or if there was a will, he will do it in accordance with the will. With one limitation, and that is that he will only do it according to the will as long as it does not go against the Spanish system of obligatory heirs. Otherwise, he will modify himself to put it in, to keep the will as close as possible to what the testator wanted, but complying with the Spanish system of obligatory heirs, which I've explained in another video what that would actually mean. So once he's done his partition notebook, he sends his proposal to all the beneficiaries. If they agree, the Secretary of the Court prepares a document by decree that he divides the inheritance, and that's the end of it. If they don't agree, if any of the beneficiaries, once notified of the partition notebook, do not agree with the partition, then a trial hearing takes place in which the accountant is present, and at the end it will be the judge that will, after hearing the accountant and the parties, will decide on the final division of the inheritance. So the bottom line to all this is that if you have an inheritance in Spain and there are discrepancies, try by all means to reach an amicable solution by using a sensible lawyer that represents all of you to try and help you reach an agreement. If that is not possible, and because there's one person that does not participate or just becomes passive, doesn't do anything, or has completely unrealistic expectations, the sooner they hire their own lawyer, the better. And then let the lawyers talk to each other to see if a solution can be found. And in the worst case scenario, well, we all go to court and we follow this procedure that we have just indicated, but we need to try and avoid it if we can. I hope you found the video useful, and if you did, please subscribe. If you need any help with an inheritance in Spain, in court or out of court, or with your Spanish wills, please contact us. Our website is down in the notes below the video. Thank you for watching.